Good morning. Please be seated. We're here today in the matter of Schires. Am I pronouncing that correctly? Schires. V. Carlat 1 CA-CV18-0379. We have already conferenced this case. We've reviewed the parties' briefs and pleadings. So when you have your argument, I'd be aware of that fact, that we're familiar with the facts and the arguments. Each side has 20 minutes. We will leave it up to you guys. I don't know if you want to reserve any time, appellant, but we won't police that for you. Have I forgotten anything? I feel like I've forgotten something. Usually I have a script, and I didn't bring my script with me today, so I'm kind of doing it off the cuff. I guess with that, we can proceed. Oh, this is recorded for YouTube, so you might want to state your name and who you represent when you begin, so that people who watch on the internet, why anyone would want to watch it, I don't know, but do that so everyone knows who you are.
Good morning, Your Honors. I'm Veronica Thorson for the appellants. And may it please the court, I would like to reserve 5 minutes of my time for rebuttal. Today I want to explain why the city's expenditures are a radical departure from gift clause precedent and the seminal case, Turkin v. Gordon, which requires that expenditures of public money, 1, serve a public purpose, and 2, garner adequate return consideration. Honors, I'd like to spend the bulk of my time discussing the latter. So everyone agrees that the government is allowed to buy things or services from private parties, but it can't pay too much for what it buys, and it also can't pretend to buy something under a contract. And this is why the seminal case, Turkin v. Gordon, gives us 3 steps to figure out whether something is an illegal gift or a proper contract. Now, the first step is to only look under the 4 corners of the contract. So
it doesn't. That may be a false dichotomy. It doesn't only have to be a possibility of a gift or a contract. There can also be the expenditure of public funds on policy goals that have no contract attached. Correct?
Well, in the case of spending money where you're giving the money to a private party,
like a charter school,
there has to be a return consideration. A charter school is a public school, and so...
Well, it's a private corporation, is it not?
But it's open to the public. Any student can enroll in a charter school, and it's free for that student to enroll in the charter school.
I'm sure that's true, but my point was really somewhat different. The government can spend money on doing things that it perceives to be a public service through the engagement of private parties. You'd concede that generally, right?
Well, that's what I was saying, that everyone agrees the government is allowed to spend money on certain things. Services, in carrying out their traditional government functions, certainly they are allowed to do that.
Okay. I mean, for example, the county, Maricopa County, spends money on programs to rehab houses for energy efficient purposes, right? That money is spent and it benefits homeowners, it benefits vendors, and presumably, at least in the judgment of the county board, benefits the public. But there's no direct consideration received back. Are you claiming that entire area of public expenditures is unconstitutional?
Your Honor, that's not what we're claiming. What we're claiming is that these 2 particular contracts, the Huntington contract and the Arrowhead contract, are unconstitutional under the gift clause and under Turkin v. Gordon.
I get that's what this case is about, but is the necessary implication of your position what I said?
That's not the necessary implication, because what the government decides to do in enforcing its policy goals is a very general concept. And
even if it involves spending money?
If it involves spending money, yes. It's just that the government can't spend money by giving it to private associations and then not getting anything back. And that's what we're claiming is happening here. So, for instance, in the case of the Huntington contract, the city is giving Huntington money in order to fulfill these performance thresholds. And those thresholds aren't worth the nearly $2 million. And so taxpayers took a panoptic view of the contracts, and we said, okay, well, let's look at it the way that the city wants us to look at it, as if it's providing, as if those thresholds are culminating in an operational university. But the problem with that is that the contract doesn't actually give an operational university to the city. It is operating in the city, but it's a private business operating for itself. It doesn't provide adequate consideration, and the reason why is because the city and its people aren't actually getting any benefits from that business operating there in the sense of something like free or reduced tuition or a general education or public use of a facility.
Wait, you said they aren't getting a general education. What's your support for that proposition? It seems like, let me rephrase my question. Could the city of Peoria decide they're going to open its own university? It's going to be a publicly owned university by the city of Peoria?
As far as I know, I don't know why that would be a problem.
And they could pay a contractor to build the building.
Sure.
Okay.
They would be getting a building out of that.
Right. And they could then run the university and charge tuition for it.
Yes, Your Honor.
Okay. Could they decide at some point that it's too burdensome to actually run the university and hire a third party to come in and run the university for them?
I think so. They would still own the university, and it would still be open to the public and providing that general education.
Okay.
That's
so
not-
they are providing education here, so that is a public benefit to them.
Well, they're not providing a public education, and the reason I said that...
That's why the hypothetical I asked, they charge tuition even if it's a public university, right?
In the hypothetical, yes, sir.
Okay. In this case, the private entity is charging tuition, but they're providing, or maybe you dispute this, but they're providing education to the students who attend it.
It's not a general education, and that was my point. It's a specialized education. They only offer one field of study, which is digital media arts. So it's not like a general education type of university where a student can go and pick any major.
How is that constitutionally relevant?
Well, it's just one of many points where it's not as if this university is providing a service to the taxpayers.
We may concur on the wisdom of the policy of pursuing one type of education over another, but that's not the same as a constitutional flaw. There are a lot of policies that are debatable, but also beyond the reach of the courts. I'm sure you
Certainly,
agree.
Your Honor.
Okay, so here, if the city makes a legislative determination that it wants to promote some forms of high-tech sounding education, and it enters into a contract to get such an enterprise up and running, and the contract is performed, I'm straining to see the problem.
Well, we try to use the example of just giving money to any other kind of business. It's very similar because if you were to give taxpayer money to a McDonald's or a Starbucks without any promised particular benefits for the people, that would be a subsidy. Of course, McDonald's and Starbucks aren't under any obligation to serve the public. They do it to serve their own interests, not as a service to the city, and that's the same thing here. Huntington isn't providing a service.
I'm sorry, go ahead.
It's not providing a service on behalf of the city. It's operating its own business.
But it means that within the city limits, there are more services to be had. Is that not a permissible governmental goal?
In this context, the way that it's being done, it's not. We have to remember that when the gift clause was first enacted, this is exactly what cities and towns and counties were doing. They were giving public money to railroads and other businesses so that they would locate there and stimulate the economy, but there weren't any real and direct benefits for the people. And instead, it was draining the public coffers, giving advantages to private interests, and this is why the framers wrote that phrase into the Constitution. It was to prohibit these location subsidies, and that's what this is, because you're essentially saying, we want this business to exist here, so we're going to give them a subsidy to establish their business. That's what it is. It's a subsidy.
And what if it's a general class-based subsidy, a tax credit or a tax deduction, for example? Instead of targeting a single business and saying, we want you here, we'll create a class of businesses and say you get a tax subsidy. Is that the same thing?
I think that is a different situation entirely. This is direct payments to the company in order to locate here.
A constitutional distinction between a direct payment and a tax credit? I'd be surprised that your client would agree to that distinction.
So this hasn't come up before the court, and so we don't actually know whether a tax incentive could be a subsidy. The words of the gift clause imply that it could be. That's not what we're litigating today, of course, but the words of the gift clause do say that no city shall ever make any donation or grant by subsidy or otherwise to any individual, association, or corporation. And
so let's bring it back to your case then. If instead of writing a check, the city had agreed to a tax waiver up to the amount of the check it wrote, would there be any meaningful difference?
If it were the exact same fact pattern as here.
Everything else is the same. It's just instead of writing a check, the city says, well, we're a little cash poor right now, so we're not going to write a check, but we will forego taxes up to this cap.
I think that's more akin to what was going on in Turkin v. Gordon, because there it was a tax incentive arrangement under the other version of 9500.11. And even in Turkin v. Gordon, the court said there has to be some kind of benefit that's not indirect, that's actually in the four corners of the contract in order for it to count as valuable consideration.
And here, the four corners of the contract say, we're going to build this thing, we're going to staff it, we're going to run it, and it will exist only within the boundaries of your city. And so the city, again, I'm not defending the merits of this policy decision, but the city says it's desirable to us to have some forms of high-tech higher education within the city limits. We now have a contract that guarantees that they're going to create this. Why isn't that a consideration?
Because the operation of a business on its own with nothing more promised to the citizens isn't consideration. It's a location subsidy. It is exactly what was happening and what prompted the gift clause to be enacted in the first place. There has to be more. The citizens have to get something out of this deal other than just another business that's operating in the city. They have to get something, public use of the facility or some kind of tuition arrangement where they pay less than, let's say, people that don't live in Peoria. There has to be something that they get out of this.
Peoria made a legislative policy decision to encourage certain kinds of economic growth, and they made the legislative decision that this project met the criteria for the kind of growth they wanted. But you're insisting that the impact on Peoria's economic growth is not consideration. Is that right?
No, Your Honor. It wouldn't be consideration, and the reason why is because there's nothing in the four corners of the contract that says Huntington promises to create this amount of economic impact in the city.
No one could promise that, but they did promise to build the university, which is a clear distinction from Turkin. In Turkin, the only thing the city got was parking spaces.
With all due respect, Your Honor, the city actually did get parking spaces. That was something tangible, but if you go back...
So de minimis and disproportionate to the money expended, because there wasn't even an agreement that they would even complete the retail space in Turkin.
Right. Yeah, Your Honor. And it's we have to remember that in Turkin, what the city of Phoenix wanted was for the development to happen so that it would stimulate the economy. They didn't actually pay $97 million because they wanted parking spaces. They wanted all the indirect benefits that this project, this large project, was going to bring. That was actually discussed in the appellate court.
Right. The Supreme Court said that those indirect benefits from the encouragement were not palpable enough to constitute consideration. But that was because there was no agreement they were even going to finish the thing.
Well, it's kind of like almost the same thing that's happening here, because the court in Turkin said, yes, there's no obligation to build it. It's just that these payments are based on, if you do finish these steps, then we'll give you the payment.
Wasn't this project already built when you challenged it?
Yeah, and we're not challenging that. We're saying that this is akin to Turkin because basically the city is saying if you build your business, if you're here, then we'll give you money. But
you're asking for the remedy that the Turkin court was afraid to give, right? I mean, you're actually asking to unwind this deal.
Well, actually, taxpayers are seeking to enjoin the further effect of the contracts. There's still some time left on the contracts. There's some payments left on them. But, Your Honor, we would be happy seeking also prospective relief so that cities understand that they can't just give money for the location of a business. And I only have 5 minutes left, which I'd like to reserve, but I'm happy to answer.
I will give you some more time because I have a question that I want to ask before we get to rebuttal. So stop the clock for just a second and we'll go off the clock. There you go. You got your 5 minutes for rebuttal. I'm a little troubled by the dichotomy that the parties presented to the court below. You guys, taxpayers said 0. That's the only way to value this promise. And city says, no, the only way to value it is the anticipated economic benefits. And I'm having some trouble squaring this anticipated economic benefits with Turkin saying you can't generally consider indirect benefits as part of the consideration unless they're explicitly bargained for. I understand your argument to be you can't consider those unless explicitly bargained for, but it does seem to me that there is some value to, even if it's just, let's say out of the 1,000 students who will be attending, we can estimate that some percentage of them are going to come from Peoria. Even if they're not getting a discount, that still provides, even though it's not general, but some education to Peoria residents. Why is 0 the only value you guys stuck with?
Oh, Your Honor, actually, we didn't just say 0. We said if you have to
I think
put
in your
a
briefs
value,
you said 0. But
if you have to put a value on this, we're saying that the better value of economic return is the fiscal impact of the project, because the fiscal impact estimates tax revenue that the city can actually get into its coffers as a result of this university operating.
What Turkin said we're not going to consider?
It said it's not consideration, and we're saying it's not consideration. That's why it's 0. But it's a better estimate of economic return than economic impact.
So what if instead of a digital arts university, this were a cancer treatment center, and the city made the judgment, we want our citizens to have easy, convenient access to cancer treatment, no matter how expensive this place actually is. And it entered into the exact same agreement, but the anticipation was that this real estate would be used to treat cancer at fairly high, sophisticated rates, not to teach digital arts. Would that change your analysis at all?
Your Honor, appellants aren't challenging whether the city's goals are laudable or not.
I understand, but I'm really looking for, would it change your analysis at all?
Your Honor, I don't think so, and that's why we bring up the point of the McDonald's and the Starbucks, because a business, any business brings a unique desired service into a city, and the reason why we said Starbucks...
But this isn't just any business. And I know this is kind of mixes the public purpose versus the consideration, but this is a school. It's education, which is clearly one of the things that governments are allowed to promote and do. So it's not just a Starbucks or a McDonald's.
Right, Your Honor, the words of the gift clause really help to clarify this because the cities aren't allowed to provide subsidies, and the definition of the word subsidy today and also at the time that the gift clause was written is that a subsidy is a grant of money made by government in aid of the promoters of any enterprise or which is considered a proper subject for state aid because likely to be of benefit to the public. In fact, that's what's going on here. We believe that these are likely to be of benefit to the public, but the problem is that they're subsidies nonetheless because the consideration is lacking.
All right, we should, you've got 5 minutes left, unless there's any further questions. Okay, thank you.
Thank you.
Good morning, Your Honors, and may it please the Court. Mary O'Grady representing the City of Peoria. And I, too, will focus on consideration. Here, the public purpose is obviously it's part of an economic development program that Peoria developed to attract certain businesses within certain areas to the community and provide additional educational workforce opportunities. And as part of that, they identified an opportunity with Huntington University, and this agreement is to what they're bargaining for, the bargain for exchange here is to get Huntington University to operate open a branch, operate a university within the boundaries of Peoria. Now they keep talking about, the value has to be within the four corners. And Turkin doesn't use that language, but what it talks about is what are you bargaining for here? And so that's what matters.
But I guess the McDonald's and Starbucks analogy then does kind of have some sway, right? Because you could make exactly the same argument you just made to have a Starbucks on every corner. If the council decided, boy, it's great for the economy to have people congregate at Starbucks, we're going to have 4 Starbucks per intersection, and we're going to pay for it. Isn't that the same argument you're making about this?
And a highly caffeinated workforce is better than a highly educated workforce.
Well, here I'd have to look at the specifics. When I was thinking of the example, this is slightly different than yours, Your Honor, in terms of like McDonald's, for example. If I'm a community on a freeway and have the opportunity to get a McDonald's in my town, that may well be part of my town's economic development program. And you do the analysis to see whether what they're doing makes sense given whatever specific agreement they've crafted.
You
and
want the courts to start determining whether economic development policy makes sense, would you? I don't know that we are confident to do that.
True. What I mean, whether it meets the constitutional standards. In terms of the court's role, they're looking, when in terms of public purpose, in terms of whether it's an unquestionable abuse of discretion. And I think it's obvious that economic development is a fair role for government.
Well, sure, but if we change the facts a little bit, and instead of this university, we have the exact same deal to build the world's biggest Starbucks. Any difference constitutionally?
I think...
I mean, it'd be a heck of a draw, right? Starbucks fans from all over the world would fly to Peoria.
You'd have to look at whether the consideration is so inequitable and unreasonable that it amounts to an abuse of discretion.
That's if you assume that the economic development alone satisfies public purpose. I mean, I'm willing to give you the education benefit as a public purpose and move to prong 2 on consideration here, but don't you at least admit there's a little bit of a different analysis with Starbucks versus a university on the first prong?
Well, I like my case better than the Starbucks case, frankly.
I mean, we disagree sometimes.
Well, I guess I can certainly see arguments going both ways, but I'm interested in your argument as to whether your position would have equal merit if this were a Starbucks. I could imagine a principled argument going either way.
I think if you'd apply the analysis, and you'd apply the same analysis to the Starbucks situation. And is the consideration so inequitable and unreasonable that it amounts to an abuse of discretion? I still think you go through the tests and see what happens. So I don't think that Starbucks is constitutionally off limits, but I think it's a tougher case than we have here in terms of the consideration and what's, whether you really are, here we have in the record that they wouldn't have been in Peoria but for these incentives. We needed to do this to get Huntington University to operate a campus in Peoria.
Okay.
I don't know if they'd have the same record.
So when your definition of consideration, and I have to admit, I find our case law fairly unhelpful in its definition of consideration and its use of the terms direct and indirect, because I think almost any form of putative consideration could be argued to be direct or indirect depending on your perspective. So if we get down to a more workable definition of consideration, I haven't given a lot of time to prepare for this question, but could you articulate what you think is a workable definition of consideration under the gift clause?
It's the value of the promises exchanged. So it's looking at the value of the promises. So what is you have a bargain for exchange, which is
the value to whom? Is it the value to the government, qua government?
Okay.
Is it the value to the community? Is it the value to certain citizens in the community? When we say value, I think one of the reasons experts can disagree so easily is value to whom that matters.
That's a really good point. In the context of governance, what you're looking at is the value to the community, because that's really what the city council is looking at. And they're governing the community, so it's the value to the community. So if you're negotiating...
Isn't that argument completely thrown out by paragraph 34 of Turkin, though? Paragraph 34 of Turkin gives the hypothetical of the busted sewer line. It says clearly the value of repairing that sewer line is $5 million to the community because of all the health benefits and everything that comes from having that sewer line fixed. But it would still violate the gift clause to pay any more than $5,000 for the repair. And I'll say that saying, I read 34 as saying you are wrong. I read 33 as saying you are right, which is 33 says that you can, if you bargain for these benefits, even if they're indirect, they can be considered consideration if they're part of the bargain for benefit. So I almost read that saying you could do this sewer line repair if you, instead of bargaining to repair the sewer line, you said, we'll pay you $5 million to improve the health. And then that would suddenly be okay, but if you say $5 million to repair the sewer line, it's not okay. That's why I think when Judge...
That's my frustration with the case law, yes. I think it can be read to support either position.
I think that the key is the objective fair market value. How do you value that? With the sewer line, I view that as the objective fair market value of fixing the sewer line is what does it cost to fix a sewer line? $5,000. Here, what's the objective value of having Huntington University in the community? That's why you look at the economic impact. This is an economic development program.
It seems to me like if you're looking at objective standards, it would be figure out how many Peoria residents are going to be educated at Huntington and put some kind of figure out what the market value of educating those residents would be, and that's the fair market value of the university to the public of Peoria. Maybe you add in a little bit, adds a little cachet, so we'll add another $100,000 for the reputational benefit, goodwill benefit. I mean, it seems like, but just this writ large, I don't know why I keep saying writ large, but this big number of, anticipated economic benefit seems to kind of run afoul of Turkin to me. So I don't how we can reconcile these two numbers.
See, I think that is the objective fair market value of this economic development program. They're spending this money to get this business to locate in Peoria. What's the objective fair market value? That
would be the objective fair market value of the sewer repair too, wouldn't it?
No, I think in the sewer repair, it's what does it cost for the sewer repair, and it's $5,000.
Is it the difference between a repair, which is a cost, and an investment? In other words, if instead of repairing the sewer line, we were going to build a new one, could we get some more constitutional leeway on the creation of a glorious new sewer line instead of just patching the old one?
Yeah, I don't think that's when you get into legislative judgment calls to some extent. I don't think the Constitution would impede the community's ability to build a new sewer line rather than replace the old for less cost.
Council, that you mentioned the legislative judgment issue, and I think instead of talking about sewers, I mean, we're talking about education here. And I mentioned before that the City Council developed a plan not just to encourage a certain amount of economic development, but to do that in a certain way, and specifically identified high-tech, innovative new technologies and higher education as the way Peoria wanted to channel its economic growth. So then this project is presented, and they make the legislative determination that it would not only provide beneficial economic impact, but in the qualitative ways that the city had determined. Are you privy to what went into the determination that high tech and higher education, that these would be the quality of the economic development would be advantageous to Peoria citizens? I mean, I can imagine why you would say that. High-paying jobs, getting a reputation as a center for development of high technologies and economic development with a future. But were there particular qualities about that kind of growth that Peoria was attracted to?
What we have in the record is kind of the results of their thought process in the development of the EDIP program, the Economic Development Program, which focuses on those in part because of the looking at industries that have some growth potential, looking at industries that do have some earning potential, looking at things that would, work geographically, and things that they thought were feasible in their community, that would work for their community. And then they, came up with their legislative approved economic development policy, of which this is part of that effort, to recruit certain types of industries, provide certain types of workforce training opportunities in their community in these targeted areas. If that helps, Your Honor. And so all of this is wrapped up with these kind of legislative judgments about what's important for the community of Peoria. And in terms of valuing that, again, when I look at Turkin, I look at, that's about what did you directly bargain for? In Turkin, they were bargaining for parking places. Here, they're bargaining to get this university located in Peoria. And so how do you value that? It doesn't matter about what goes in the city coffers and what doesn't go in the city coffers, because that's not what this is about. That's not what a lot of public entity decisions are about.
Wouldn't consideration also necessarily include consideration of the university's forbearance to build somewhere else? The university has the right to go wherever they want, and maybe some other locations would have other advantages to the university, but they in this agreement they have given up those other opportunities. Isn't that some value in determining consideration?
That's a good point, and they do specifically.
Forbearance can be part of consideration in normal contract.
Yes, and they do have that provision in their contract here, where they're not going to locate anywhere close to Peoria, in the specified period of time. Now, I think that is part of the consideration when you're doing this analysis of what's grossly disproportionate. It's hard to stick a number on, but it's absolute. There's value to that.
Yeah, I'm not even sure. I'm not even sure a number's needed. Mm-hmm. I mean, when you look at Turkin, parking spaces, way up in North Phoenix is such a de minimis kind of return on a big investment. It obviously wasn't what the city wanted. The city was kind of speculating that they would get some benefits, and that's why the Supreme Court talked about that as being too indirect to count. Mm-hmm. But this is qualitatively different, it just seems.
Yeah. It seems that everything you're talking about could be characterized as indirect. So are we saying that there is a spectrum of indirectness?
See, I don't think it should be analyzed as indirect, because the forbearance piece, that's in the contract, that they can't locate, within
Are there
another
any
campus
evidence
in
in the record
Peoria.
as to what the value of that forbearance is, though?
Well, and that's true. There's not a record of the value, partly for the,
You guys
they
didn't
don't.
assert that below, that the forbearance had a value.
We argued that the contract has a value. The value that we focused on was what we could cost out in terms of economic impact, which is clearly what's negotiated for.
That indirect under Turkin, because certain types of economic impact that I think almost everyone would agree are beneficial to a city were ruled not validly part of consideration in Turkin.
No, because in Turkin they were negotiating for parking places. Here we're negotiating for a university to locate in Peoria.
The argument was we were not just negotiating for parking places, we were going to get all this tax revenue. And so it would be a net gain for the city.
But this agreement, those were arguments about the indirect benefits of the project. Here, we are negotiating for the university as part of this economic development
So what's the direct
plan.
benefit to Peoria from not having this university in Mesa? What do they care?
Well, they don't have the competition for the students in the marketplace, so it helps enhance the success of the university in Peoria. And we negotiated for other provisions in the contract, again, that are difficult to price out, but
And as a policy and business matter, I can well understand why that makes sense, but I have trouble cramming that argument into Turkin.
well, I think the basic argument fits neatly within Turkin. The question is, what did you bargain for? If you didn't bargain for it, the problem with those indirect benefits was that's not what they were negotiating for. They were negotiating for parking places. We are negotiating to get a functioning university within Peoria that fits the parameters of this agreement.
Let me ask you some specific questions about that bargain. Did the contract actually obligate Huntington to open and operate the campus for a period of time?
If they're going to qualify for the incentive programs, yes, they needed to.
Well, then how is that different than Turkin? Because Turkin said specifically they didn't covenant to build these things. It was just a condition precedent to receiving these. And it sounds to me like what you're saying is that that's the same thing. You guys only will receive the incentives if you do this, but you're not actually obligated to do it.
This whole contract is about getting a university in Peoria. That's the distinction.
The whole contract with the city was about providing the parking spaces, and they said, this is not a condition precedent, or they said this is a condition precedent, this is not a covenant, which...
No.
Right.
But
So
they-
it incentivized a big economic development in North Phoenix. Well, I mean, I think the question is a fair one. If there was no obligation to actually open and run the university, how do you distinguish it from Turkey?
Well, this is what, again, they're negotiating for in this agreement. If they don't comply with the agreement,
Well, they couldn't be
Then-
sued. If they said, we don't want to open a university, they couldn't be sued for that. They just wouldn't get their check, right?
if they say that after some partial performance, then they would be in breach of the agreement and they would owe money back. So some of
You
these...
could never sue them and say, you violated your contract with us, you have to open the university or pay us damages for your failure to do so.
Well, you're saying that the damages they would have to pay were the money they had received to that point, right? I may have misunderstood the contract, but I was rather under the impression that failure to satisfy the condition would only affect future payments.
No, there are obligations to repay, and I'm looking at the breach notices. Here, if they don't meet the performance thresholds, there's an obligation to repay. Again, the distinction is that these thresholds for when you get the payments are different than the thresholds in Turkin, because again, that contract, this is directly about getting the university to operate in Peoria. It's not about some auxiliary thing like Turkin was about the parking places.
Wasn't the university required to participate in other of Peoria's economic development activities?
That's another requirement here. Again, difficult to price out if you're
Is
really
it, or
trying
could
to.
you just put out a bid for contract with various universities in the area and see who will help us with economic development activities and provide whatever expertise you may have.
Well, my question wasn't
has
about
value.
its value, but the fact that there were obligations in the contract that carried beyond the building of the building.
And that's true. HU will participate in economic development opportunities with the city, so it had that obligation as well. It had the obligation, with regard to where they could open other campuses.
Is
It
that a
has
covenant
those
that they would do
obligations.
that, or only if they actually provided and operated the university, which they didn't have to do?
It's independent, HU and city obligations and verification. So HU will participate in economic development opportunities with the city, and it doesn't link that to the other performance commitments.
That can be things like job fairs and counseling for employment opportunities.
Absolutely.
It could be for encouraging people to enroll in the university.
Absolutely, absolutely. So that all kind of adds value to this program, which is part of the overall legislative determination of.
Well, it's also
that this is-
inconsistent with them building a building and then walking away.
There's a lot baked into this to make sure that the city got what it's bargained for, which is an operational, functional university in Peoria and advancement of its overall economic development program. And I see that I'm out of time, Your Honors.
Okay, thank you very much.
Thank you, Your Honors.
Your Honors, I just want to point out that in paragraph 3 of Turkin, you can see that the city of Phoenix wasn't just bargaining for parking spaces. They actually, the developer said, we can't complete this development without money from you. And this is why the city of Phoenix entered the contract. As I think one of you correctly noted, that's really what that agreement was about. It's just that the only contracted for tangible benefit that ended up being in the contract was the parking spaces. And that's why the court latched onto that as consideration, because none of the other things were in the contract and couldn't be consideration. And that's what we're arguing here. There is nothing in there for the citizens of Peoria, and the reason why
That's the opportunity to go to a university.
and that's no different than the analogy to the Starbucks, which I do agree being caffeinated is way more important than being educated.
Well, what about being cancer-free? I mean, it seems like we have this spectrum between Starbucks, Digital Arts University, and cancer treatment, and I'm not sure that your position differs among any of them.
Right, and this is why, regardless of policy decisions, because people are always going to value different things, but that's why there has to be something in the contract for the people, regardless of what one legislator thinks is more important than another.
The opportunity for frail members of the community to get to their treatment more easily be a community benefit that would be cognizable.
I think it just has to depend on the way that the agreement was structured.
Well, no, I'm asking you the hypothetical now. I'm interested in your reaction to that hypothetical. Exact same agreement, except the perceived benefit is that people who might otherwise be unable to travel a long distance to get life-saving treatment can now get it right near home. Is that good?
Well, it depends, though. I mean, is the city providing a way to get that treatment or just an opportunity to get it because this business exists in the city? If the city's actually saying, we're going to make your cancer treatment less expensive than it would be under this
Not
contract.
just less difficult. I mean, certainly there's a value to having a hospital next door as opposed to 50 miles away. I mean, I don't see how you could argue there's no value to that. It's just a question of how do we value it, right?
There is value to businesses being in the community. I don't think that's in dispute at all. We all value different types of businesses in the community. But the problem with just paying a business just to be in the community is that it's a location subsidy. It's prohibited by the Constitution. The original
The Constitution
intent,
doesn't say the word location subsidy, though.
it does say subsidy, and we know what subsidy means, and I would urge the court to examine the meaning of that word.
And you've got to be careful what you wish for there, because there are a whole host of subsidies that the government engages in that I think could be subject to the same semantic argument we're having today, but are fairly universally recognized as legitimate legislative determinations. I could rattle off about a dozen of them right now.
Your Honor, that's true, but there does have to be some line drawing. Otherwise, we can pay any business to locate within a city, and as long as an impact study says that spending money is going to stimulate the economy, then it will be okay for that business to locate.
And that's really not fair to what Peoria did here. The people that they elected, the people in Peoria elected to make these legislative policy decisions, they, with foresight, looked at what kind of economic development. And you say, well, we can all differ about what kind of economic development would be best, but these are the people that were elected to make those determinations. And the question is, are they sustainable? And we live in a representative democracy. These are the people that we hire through our elections to make those policy decisions. The Constitution doesn't preclude that.
Your Honor,
this isn't just rank gross economic development. It's just a certain kind of economic development with a certain kind of benefit anticipated to the city.
Your Honor, I understand that, and what makes this difficult is because the Constitution does say that the government is not allowed to give subsidies to private businesses, and we know that a subsidy is something that the government thinks is a good thing. This deal would be completely different if, like in the hypothetical where you said, well, what if Huntington decided to open its own school and it was a public school? But that's not what's happening here. Turkin makes the very clear distinction between benefits that are bargained for and indirect benefits that are not in the contract.
Indirect benefits in Turkin were from the hoped for but unbargained for eventuality that the thing would be built. Here they bargained for the thing being built.
Well, it's not quite like that. In Turkin, we had nearly the same situation. I mean, it's very much apples to apples, because in Turkin, regardless of whether they ended up building it or not, what the city wanted was the economic development that would come from that project. And that's why they entered into the contract. Only there was a tangible public benefit. It just wasn't enough to satisfy the gift clause. Here, we're arguing that there just isn't a tangible benefit for the public because it's just an opportunity to pay for a business.
The only tangible benefit that the Supreme Court would agree to consider was that would result from what was bargained for, which was parking spaces. Isn't that correct?
I'm sorry, Your Honor, that was the only tangible consideration in Turkin.
Because that was all that was bargained for.
Because it's the only thing that the four corners of the contract promised the city would get. And here...
It's parking spaces.
Right. And here, again, we're arguing that, well, the city's arguing that the performance threshold, which are tied to the payments, they will culminate in an operational university in the city. But... again, this is where the line drawing comes in. I know everyone agrees education, laudable. Some people, cancer treatment, laudable. But it's paying a business to locate with no promised benefits for the people. Yes, there is an opportunity to have a university in your city, but the people they just don't get anything from that because they're not getting.
The people, I think, statistically, it would be beyond dispute that more people choose to locate in Phoenix than Eloy, right?
I would imagine
Populations
so,
are
yes, sir.
different, right? and so people choose to move to Phoenix, presumably because they want access to all sorts of business and services, and then some people choose to move to a smaller community because they actually want to get away from that stuff. That's a legislative determination whether you want to promote a busy urban type of environment or the opposite. Argue it both ways. Isn't the fact that so many people choose to live in concentrated areas with businesses and services a suggestion, or doesn't it give rise to an inference that at least the people think they're getting something out of that concentration of economic activity?
I think that has to go to public purpose rather than consideration, because it is an indirect benefit of of paying a business to locate within the city. Whatever benefits might be spurred from that, whatever benefits people appreciate from that, it is indirect. And Turkin, again, it said that these things might be relevant for talking about public purpose, but when not.
So what does indirect mean to you? Does it mean anything that is not in the form of property or money conveyed to the city as a body politic?
Well, I'm only looking at it in the context of Turkin, where it says that indirect benefits that are not specifically bargained for in the contract are not consideration. So I'm looking at it as these indirect benefits they're not in the contract.
So,
and
but the indirect benefits that, or the benefits that we've talked about all morning are in the contract. It's just a question of whether they're too indirect, even though they're in the contract, right?
Well, they're not in the contract, though. There's no economic impact in the contract. There's no.
But that would be impossible, right? You couldn't credibly enter into a contract that says I'm going to have this much economic
Right,
impact.
exactly. But you could.
So then what you're really arguing is that indirect benefits are always out because they can't be put in a contract, and that the direct benefits, which are the money or property received by the government directly, are the only measure. Is that right?
Well,
Because if you want a holding that says that, be careful what you wish for. The effect of such a holding on a whole host of other activities would be dramatic.
Your Honor, taxpayers were saying that if there is a number to put on the location of a university within the city, it has to be something that the city's actually going to get, and that's why we put a number on the tax revenue. The city will definitely get more tax revenue from a business operating. It's not consideration, but at least
in the contract.
It's just a value of the contract. That's not economic impact as a value, because economic impact is putting a value on indirect benefits. Turkin says we can't do that. Tax revenue, also not consideration, but it's putting a value on the university being in the city, because it at least shows what the city can actually get from the university being in the city. Again, we have to remember.
Like an awful lot of indirect benefit to me.
It is an indirect benefit.
Which we're not allowed to consider.
I know we're in a hard place because we're saying zero, but here's the value. They're saying, well, here's the value. So we're in a situation where the court has to figure out what is the better way to value the contract.
Yeah.
And that's a tough position because, in the trial court, we did try to figure out what the value of the individual thresholds was, and plaintiff's expert couldn't do it, and the city's expert couldn't do it. And so it's just a very difficult. I think the reason why it's so difficult to put a number on the location of a business, an operational university, is because, if you really look at it and take a sober approach, it is a location subsidy. It is. I would urge the court to go back and look at the words of the gift clause and to look at the definition of subsidy, because that is your answer. There is just no direct value. There's no consideration that goes directly to the people, and it opens the floodgates to pay any business just to locate in the city with, again, no promised benefits for the people other than the indirect benefits that will be spurred from the project, which Turkin says simply can't count as consideration.
Thank you very much for both parties for your arguments today. We will take this matter under advisement and issue a ruling in due course.